All right, guys, we're back for Chapter 8. It's non-enforcement of contracts. And believe it or not, we're roughly 2/3 of the way through our curriculum for Commercial Law 1. So be excited by that. Non-enforcement of contracts. We're getting back into these principles of contract law and what's necessary in order to be able to enforce a contract, in order to make sure that one party can uphold the sanctity, the validity of a contract in case the other party or parties violate the contract. So you'll see this starts on page 166 of your text. And it starts again with our handy-dandy hypotheticals, this time involving Martha Smith buying a fitness club in downtown Toronto. Please read over that hypothetical. It provides you with the continuity that you need in order to be able to understand the concepts in this chapter, just like similar hypotheticals did in previous chapters. You'll notice, of course, in the Martha arrangement, it's her parents and her financial arrangements with a bank. When we talk about, in general, though, the enforcement of contracts, we're discussing again, what mechanisms can be used to enforce a contract, and we'll discuss those in the coming minutes. We're going to start off by discussing what types of circumstances will actually result in the inability to enforce a contract. And that really effectively starts toward the bottom of page 167 and then much more so on page 168. Before we go into that, there are two distinctions, and they're important distinctions. You'll see it on the left-hand bar, page 168. The difference between a voidable contract and a void contract. So a voidable contract, as you'll notice, is a contract that in certain circumstances can be kept in force, can be reaffirmed by the party who's been violated by the other party. So it's not just completely void, null, just done and over with. It's voidable, meaning that the party who has been, well, for lack of a better word, screwed over, has the ability to then say, okay, I have been screwed, but I want this contract to continue because long term I think I'm going to get more benefit by continuing the contract despite the fact that a certain circumstance has arisen. All right? So a void contract, again, is much easier. It's void. It's a defect that is so substantial that it can't be enforced and can have no effect. So again, the issue is void versus voidable. Some contracts are not just completely void. We're going to discuss the void ones. But the voidable ones are ones that at least give an opportunity for two or more parties to continue on with their contractual relationship despite those circumstances. And we'll go into what circumstances might be voidable as opposed to void. When we get into contracts based on unequal relationships, we get into, first, this notion of legal capacity. Does one party have the ability to have the legal capacity, the ability to understand, comprehend, acknowledge what they're contracting for? And we touched on this a few chapters back when we first got into contracts. What is it? I mean, and they provide you, the book provides you with a couple of different, the key, in fact, issues that involve this notion of legal capacity, spanning pages 168 to 170. The first one's minors. Do children have the ability to contract? And generally speaking, the answer is no, they don't. There are some exceptions, including under Nova Scotia law, that are known as beneficial contracts of service, where they could be considered enforceable. And they give you a couple of examples. The first one, of course, is right there, the next to last paragraph, page 169, where an employment contract with a minor is enforceable if the employer can show that the contract contains a significant element of training and career development, such as one would expect in a program required to enter or progress through a trade or profession. A minor can contract for that. Additionally, under Nova Scotia law, a minor can contract for other essential services, such as food services. And those contracts are enforceable. But generally speaking, a minor does not have, under the law, the capacity to be able to sign off on a contract and to have that contract enforced against them. Normally, it's the parents stepping into the shoes. So for instance, if you have student aid, if you have student loans, and you're below the age of 19 here in Nova Scotia, who is co-signing for you on those student loans? Normally it's your parents. Otherwise, in all likelihood, you're not getting those student loans. The province understands, even though it may involve some type of essential service, so they'll say, that in order to be able to enforce a financial arrangement with somebody below the age of 19, that they're going to require parents to actually sign off on it. So the next example you'll see on page 170 is mental capacity. Should you be able to contract with somebody who might be mentally impaired, might be what we call a mental health consumer, who is incompetent to be able to understand what they're doing, or somebody who is so intoxicated that they do not have any real understanding? So, is it fair of you, say that you're at a St. Patrick's Day party in downtown Halifax off of Agricola Street, and you're in one of the local pubs, and your friend is getting completely wasted at St. Patrick's Day? Is it fair for you to then hand them something that says, you will give me your car for the sum price of $20, which can be paid off in beer, all right? And you pay the $20 in beer, and you tell your friend the next day, you sold me your Mustang. Is that fair? Is that right? Is that enforceable? Well, no, it's not, okay? It's an issue of fact that the court's going to have to ultimately determine, but if your friend was completely intoxicated to the point where they were not competent to actually make that type of decision, then the court is not going to enforce that type of a contract. The next issue that comes up is this notion of duress. You'll note that bottom of page 170, top of page 171. Economic duress is defined at the bottom of page 170. The threat of economic harm that coerces the will of the other party and results in a contract. Duress is by force. It's essentially, if you have to put it into just layman's terms, it's blackmail. If you don't do this, guess what's going to happen? If you don't sign away this piece of land, I am going to shut down your business. This is what we're talking about here. Forcing somebody to sign off on a contract that they don't want to have to sign off on. That's a form of duress. That type of a contract is unenforceable. You'll notice on the top of page 171, last paragraph of duress, there's no possibility in our hypothetical that Martha's parents can rely on duress to avoid their obligations under a mortgage. Though the bank was going to seize Martha's fitness club equipment and offer it for public sale, this threat did not amount to duress. All right? That's, in that particular hypothetical, the bank has that legal right. It's not duress. That's just what happens through the legal system. If you don't pay, this is the consequence of non-payment. And that's not economic duress. Economic duress is entering into a contract under some threat of some type of harm. It's coercion to enter into a contract. That type of activity, that type of circumstance cannot be enforced within the courts. The next one is undue influence, which sounds a lot like duress. Effectively, it is like duress. Undue influence is essentially, well, we use blackmail, and it's blackmail in a different way. It's extortionate, if you've heard that phrase, extortion. If not, please look it up. Undue influence is defined on page 171. Unfair manipulation that compromises someone's free will or choice. And they traditionally have it defined in two different circumstances on bullet points on page 171. Actual pressure and presumed pressure based upon a special relationship. All right, so please review these. This is extremely important, and you will be assessed on how well you understand these factors. Any hypothetical that comes out of this class on an exam or on an assignment should incorporate these types of issues. So please read them carefully. Was there free choice? Becomes the issue with regard to undue pressure. Page 173, we get into unconscionability. And these factors actually arise more frequently than you could ever imagine. It's an unfair contract formed when one party takes advantage of the weakness of another party. You're going to have to show that there is inequality between the parties, and you're going to have to show proof of some type of improvident bargain or proof of exploitation. Normally, the hypothetical that comes out is you think about the elderly citizen who is contracting for perhaps a roof or for some other service, and they don't know exactly how much that service necessarily costs, and end up paying out an extraordinary amount more than they would normally pay out with a much more honest contractor. Can that be enforced? The answer should be no. And ultimately, it's going to be up to the elderly citizen to be able to prove up that this was an unconscionable contract, that they didn't know any better, that there was inequality in negotiating and understanding exactly what was happening. Does the contractor have an edge over the naive consumer? And the answer is, in many circumstances, yes. Does the elderly consumer have the ability to be able to discover what the normal price is before they get taken by an unethical, a dishonest contractor? And that's an issue of fact that the court normally needs to determine. But unconscionability comes up regularly in contract disputes because normally you're finding that people are on unequal terms. The next section, and again, it's a pivotal section. This entire chapter is pivotal because it will explain to you what you need, what steps you need to take to protect yourselves in business as well as in your personal lives. Misrepresentations and important mistakes. And there are various categories under both misrepresentations and mistakes. And oftentimes, and this is where you're going to find this notion between what's void and what's voidable coming out much more clearly, depending upon the nature of the misrepresentation, the nature of the mistake. So you'll see starting on page 176, misrepresentation is a lie. Is it an innocent lie? Is it done negligently? Is it done intentionally? And what the actual remedies are for such a misrepresentation. Before we get into misrepresentations itself, look at the 5 bullet points on page 176 that deal with the duty to disclose information. All right? There is a duty to disclose information by one side to the other side and vice versa. And you'll see one party provides only, what happens if one party provides only partial information to the other side, one party actively conceals the truth, one party neglects to correct an earlier assertion that when stated was correct but is no longer so. The parties are in a relationship requiring the utmost good faith. We call that a fiduciary relationship. And we have, when there's a statute imposing a positive obligation to disclose certain information. These are considerations that you have to give every day in business and every day in life. If you're going to be contracting with somebody, you have these affirmative obligations. You can't provide only partial information to the other side. You can't go off and sell your used car and not tell somebody that the engine's about to explode, if you know it. You can't tell them that it's nothing more than what we used to call a jalopy that may run all of about 100 kilometers before it just kicks out. You have to give essential facts. Maybe the fact that the car has been involved in several accidents, even though you can't tell because of the body work that was done on the car. These are things you have to tell. Actively concealing the truth, that's a fraudulent misrepresentation. And we're going to get into that. Neglecting to correct an earlier assertion that was correct but is no longer so, you have an affirmative obligation to correct something. And they give you a quick example there. Being involved in a relationship involving the utmost good faith, and they give you an example in insurance law. Insurance companies have a fiduciary relationship with you, the person who holds the policy. People who run what we call a trust, people who are called the trustee, have a fiduciary relationship, or a fiduciary obligation to act with the utmost diligence and to act with the utmost good faith to the people whose interests they are safeguarding. And they have to make sure that they provide absolute, complete disclosure to allow for the people who are supposedly benefiting from that relationship to be able to make accurate decisions. Or where there is a statute. And of course, the law can impose certain obligations, such as when the law imposes certain affirmative obligations on a corporation to its shareholders, under either the Provincial or the Federal Companies Act. Page 177. Ingredients of actionable misrepresentation. They provide you with the elements. The elements are right there in bullet points. Please know what they are. All right? It's important with regard to the falsity of a misrepresentation, that it's clear and unambiguous, that it's material to the contract, that it has an impact on something that could affect the whole contract itself, and could impact the decision of whether or not somebody decides to enter into a contract or to modify a contract. One that induces the aggrieved party to enter into the contract, as I've just stated, and it's concerned with a fact and not an opinion. This is a misrepresentation, an actionable misrepresentation, which means that someone can be sued in court for that. They give categories of actionable misrepresentations, and there are 3. There's a fraudulent misrepresentation, and all of you should understand what fraud is all about. There's a negligent misrepresentation. Negligence implies, as we've been discussing and we'll discuss again, this notion of carelessness. And then there's an innocent misrepresentation. It's just something that happened. The person who actually made the misrepresentation didn't know any better. So you have to be able to assess whether or not there's fraud, there's negligence, or whether it's innocence, and what the overall remedy is what's discussed next toward the bottom of the page. And you'll note what the remedy is in a clear Figure 8.2, remedies for misrepresentation. If it's a fraudulent misrepresentation, then the contract can be canceled out, rescission. And that's in contract. Separately, because it's fraud, as we'll discuss, you can also sue for fraud as a matter of tort law. And again, we've discussed this, but we'll discuss it again. There's a clear division between contracts and torts. Torts involve personal injuries. Contracts involve injuries, but specifically under contracts. So a person can be sued under both a theory of contract as well as tort. And this is very true when it comes down to this issue of whether there is a fraudulent misrepresentation. In tort, the person who has been the subject of the fraud can seek other damages to compensate over and above whatever they may be able to get under contract. As you've seen, the only thing that you can get in contract is to rescind, is to cancel out any obligations under the contract. Okay, but then what makes the person whole at that point? It's by actually asserting in court a separate complaint for tort damages that the person who has been harmed can actually be made much more whole. Additionally, because it's fraud, then there's the possibility of receiving what we call punitive damages, damages to punish the person who committed the fraudulent act. Negligent misrepresentation, you can get rescission in contract and damages in tort, but you're not going to get punitive damages. Innocent misrepresentation, an innocent misrepresentation, this is voidable. You can continue on despite the innocent misrepresentation, or you can simply rescind the contract. You can't get any tort damages, but you can cancel out the contract and say, you know what, maybe you didn't mean to lie to me, but maybe it was completely innocent and you didn't lie to me, but if I had known what I know now, I never would have entered into a contract with you, so I'm canceling the contract. On page 178, we're discussing now, and on to page 179, we're discussing this notion of mistake. All right, and you'll see the definition on the left-hand bar, page 178. It's an error made by one or both parties that seriously undermines a contract. And you want to underline the phrase seriously. Mistakes don't necessarily void a contract. Mistakes don't necessarily make a contract actionable in court, the subject of a lawsuit. All right, it needs to be a legal mistake, and it needs to be one that's serious enough that it can actually undermine the entire point of the contract. So please review that carefully. You'll note, it's not an easy question. It's not easy for me as a lawyer practicing 20 years. And oftentimes the mistakes being made are simply just common mistakes between both sides. So mistakes can result in the voidability of a contract for a contract to be voidable, but normally those mistakes are not serious enough to actually result in the ability of the aggrieved party to do so, or to take such a mistake to court. Next, we're going to come down to, finally, the last part of Chapter 8, contracts that are based on defects which will be voidable under law. Because they're either one of two things. They're void based upon public policy, or they're void based upon statute. The best example with regard to whether it's illegal under statute is a criminal act. All right? Say that you get into the situation which we've seen probably in TV and the movies, where somebody hires somebody to kill someone else. For a certain amount of money. So say that Ms. Smith hires Mr. Brown to kill Mr. Jones for $100,000. And Mr. Brown kills Mr. Jones for $100,000. And then Mr. Brown comes back to Ms. Smith and says, "Hey, where's my $100,000? And Ms. Smith says, "I'm not paying you." Can Mr. Brown, the guy who's the killer, sue Ms. Smith for the $100,000 that he was supposed to be paid for killing Mr. Jones? The answer is what? Obviously no. Nor are you going to get a situation where you have the drug dealer saying, "Hey, this guy bought this amount of meth from me and he failed to pay me. He broke his agreement with me and I want the courts to be able to enforce him paying me for this illegal drug." That's not going to happen. Nobody will enforce such an agreement. And I know those are the most blatant examples, and there are far more subtle examples out there than just that. But this gives you an understanding that if a contract violates a law, it can't be enforced. Also, even if it doesn't specifically violate a law, it runs contrary to public policy to the point where the courts cannot, as a matter of equity, try to enforce something like that. Public policy is a much more generic way of saying what the community's common sense and common conscience would allow. Is this fair? Should this contract be enforced? Or would the community say, this is not something that we would ever want to have enforced? So courts do have the ability, whether it's because something is just blatantly in your face illegal, or whether it's a violation of public policy. It's a violation of what we might also term rule of law, so that the court will not enforce any such a contract. A couple of good examples with regard to public policy come up with regard to certain sections of contracts. And you'll see two of those sections, perhaps the most litigated sections of any contract, deal with non-solicitation clauses and non-competition clauses, non-competes. And you'll see these in many employment contracts, from anyone from a hairstylist to the CEO of a corporation, where they cannot compete against their employer business for a certain span of time, over a certain geographic distance, and they can also not solicit clients or employees of the company for a certain period of time. And so, does the court want to enforce these types of provisions? I've had contracts where I've seen where the geographic zone of where you cannot compete is so wide that effectively it would make it impossible for somebody to be able to do business anywhere around where they live and they traditionally do work. It's just not fair. I've had internet contracts that I've actually written up myself where I made the geographic zone to be an entire country. And you think, well, how is that possible that somebody can't compete in an entire country? My response is, it's the internet. Now, will a court actually enforce an agreement like that? It's going to be based upon the facts of every case and what the parties are able to argue and what the court ultimately determines. Last but not least, we're going to talk about, starting on page 185, this notion of the statute of frauds. I mentioned the statute of frauds earlier in this course. It's perhaps one of the key concepts, along with promissory estoppel, that I really think that you need to know. where a writing is required, otherwise a contract won't be enforced. And they give you the types of contracts where writing is absolutely required. And I gave you an example well back when it was a contract dealing with land. That's perhaps the most common one. But you'll see the examples: contracts of guarantee, contracts that cannot be performed within a year, contracts dealing with land, and contracts for the sale of goods. Contracts for the sale of goods, it's required as well under Nova Scotia's Sale of Goods Act, as well as every province's Sale of Goods Act. But there needs to be a written agreement. So, for instance, in our hypothetical from the start of the chapter, if the bank sold the house to Martha and there was no written contract, could the bank then enforce if the mortgage is not properly paid? And the answer is what? No. Any contract for sale of land needs to be in writing. Anything dealing with a contract that cannot be performed in a year needs to be in writing. So if you hire somebody to build that house, just to build a house, and the contractor says, you know what, this is a tall order, it's going to probably take me about 18 months to do this, then that contract also needs to be in writing. Otherwise, it's unenforceable in court. We'll touch on, just quickly, this notion of electronic signatures and internet-based contracts on pages 186 to 188. Please review those. You can sign a contract now with an e-signature. You guys know that. You do it every day when you're signing receipts, when you're agreeing to certain things on websites for sale of basic goods. Your electronic signature matters in most cases. Also, internet-based contracts, which segues right into this notion of an e-signature, can also be enforced and are considered valid contracts even if they're never printed onto paper. So with that, we've ended chapter 8. Let's move on to chapter 9.